Okay, good evening, everyone. So I welcome you all for the GIAN course on WTO law and the climate crisis. This course will be, the lectures for this course will be delivered by Professor Peter van den Bosch. And so we have two tutorials in addition to his lectures. So the course is structured in such a way, the first you will have a tutorial on the general principles of international trade, because Professor Peter van den Bosch will talk about the interaction between WTO law and environmental principles, right? So to understand that deeply, and since the students who have registered for the course come from different batches, different institutions, so this tutorial is scheduled wherein it acts like sort of a capacity building work when everybody is introduced to the basic principles of international trade. So thereafter, you can better understand what is being discussed from the next lecture onwards. Right. So some of you may be aware of what is being discussed today. Most of you are not aware. Most of you are from 4th years onwards, right? You've not taken the elective on international trade law. So I request you to pay attention in today's session so that you can better participate in the lectures from tomorrow onwards. Before we jump into what are the principles that governs international trade, a little bit of history, because only when a history is appreciated, we can better understand what the contemporary things are, right? So there are basically some economic theories that deal with international trade. So I was thinking of talking about that first. Trade is not a new concept. Even in olden days, trade in some form or the other happened, right? So, but what we see is with the specialization of skills, the intensity of the trade sort of increased. So, when somebody started manufacturing a particular product more effectively than others, then his product was sold more, right? So specialization of skills is attributed to be a major factor. And at that point of time, with mercantilism as an economic theory, the government sort of had this particular attitude that we should export more, import less, and all the manufacturing should happen in our country. But this mercantilism is not going to be sustainable in a long time. The reason being, what might happen is if all the countries focus on only exporting and not importing, then who's going to import? Right. So this is something that wouldn't, in a long run, result in a economic development. At that time, Adam Smith had published his work, Wealth of Nations. That sort of then theory of absolute advantage is widely appreciated by countries. So what does he talk about was if a country has an absolute advantage over the production of a particular product, then another country, and what it should do is it should export that commodity and import those products from that country where the other country has an absolute advantage. As you can see from this particular example, what is England has an advantage with regard to? I mean, should it export cloth or wine to Portugal? Wine. It should export wine. If a particular piece of cloth could be produced with the labor of 100% in England and the same quantity of cloth requires a labor of 120%, what is England has an absolute advantage? Cloth, right? So England should export which product and import which product? Yeah. So now the complication here is if in a trade between two countries, if one particular country has absolute advantage over both the products, then in that case, can the trade happen? So that's where David Ricardo steps in. His theory of comparative advantage did talk about the possibility of engaging in trade between two countries, even when if you just compare it from the perspective of cloth and cloth, then you would see Portugal has advantage. And if you only compare between wine produced in England and wine produced in Portugal, Portugal has an advantage. But assuming if a particular quantity of cloth that is produced with a labor of 100% is equivalent to the value of a particular quantity of wine that is produced, and if there is a trade between England and Portugal where Portugal imports cloth and exports wine, then what happens is, assuming the value is same, now Portugal is getting cloth and the labor that ultimately it has spent is only 80%, right? So that way there can be a comparative advantage in a trade between two countries as well. So now the theory of comparative advantage is said to be the bedrock for contemporary trade as well. So with that, there were many other economic theories, Heschke-Roland theorem. I mean, there are certain disadvantages also. David Ricardo sort of makes an assumption that there will be constant cost and all of that. There are other factors of production as well. Factor proportion hypothesis advocates that a country should engage in manufacturing of a particular product that uses the abundant factor of production that is available in that country. So if a country has human personnel, then it should involve in a produce goods that are labor intensive, right? If a particular country has land, then it should sort of focus more on agricultural products. So that is what factor proportion hypothesis theory talks about. Then product cycle theory, this was propounded by a Harvard professor, Raymond Vernon, where he envisages a situation where a product is produced in one country, they export it, right? A certain standardization is achieved, then the capital is moved to a different country, then the production starts in that country where it is cheaper to produce the same product. Eventually, in his product cycle theory, he's talking about the cycle of a product. Eventually, what might happen is the country where originally the product was produced, it will import the product from where the secondary production had started, right? So he says this could be a product cycle as well. So the many economic theories that do discuss about the various possibilities of engaging in international trade, and should a country engage in international trade, there are many voices in favor of that. There are many factors which advocate against countries engaging in free trade. For example, reciprocity, right? The reciprocity is something that is that you could say argues in favor of free trade. So if country A exports something, then it will also import something from country B, right? If it is only one-sided, if it's unilateral, then it is exploitative. Like what happened in our colonies. The colonies were considered to be a market for selling finished goods. Again, another advantage for that goes in favor of free trade is revenue consideration. Engaging in international trade, of course, that sort of increases your economic growth, right? Then national security considerations, it could be two ways. If a country is engaged, very closely engaged in import-export, then the chances of war breaking out between the country is less, right? At the same time, the other way of looking at this thing from the perspective of national security is, if you import a lot of products from other countries, and if war breaks out, and if there is no import of that particular product, that sort of leaves your country in a sort of a soup, right? So you could examine it from both perspectives. Then economic inequality among nations. So this is again another factor which so the economic inequality among nations, right? The economic inequality sort of looked at it from this perspective as well. Economic growth of a country goes up when the country adopts liberalization policies, right? There's no question about it. But who within the country gets richer? So the section of a population that reaps a benefit out of these liberal policies could be, sort of concentrated in the hands of very few people. So country adopting liberal trade policies may have a situation where there is economic concentration in the hands of very few people as well. Then there are some questions with regard to degradation of environment, health. I mean, once your environment is affected, obviously that's going to affect your health as well. Then what about labor standards? So this is something that we all know from the Rana Plaza incident in Bangladesh. Eventually, that fire sort of revealed the ugly truth. There were many cheap laborers working in the textile industries in Bangladesh at a wage less, at a very less wages and all of that. So that is there. Then also there could be some sort of feeling self-sufficiency is better than dependency, but no country can have an autarky kind of a situation where it cannot completely rely on self production itself, especially in the context of digital developments and all of the rapid technological development that is happening now. You do need rely on certain probably raw materials or technology from other countries. Okay. So the very first multilateral instrument that regulated international trade was called General Agreement on Trade and Tariff. So why was GATT signed in the first place? Why was there a multilateral instrument for regulating international trade? If we see the history, we can see there was a treaty even in 2500 BC. Some sort of a trade treaty was there. So why was these treaties signed? So, but that is something very, it's a way long back in 2500. So the modern day international trade that we see, it has its roots in late 18th century and early 19th century. So that is what resembles our contemporary trade situation. So what had happened back then? So there we could see a rise in unified markets, and there were nation building exercise. What do I mean by nation building exercise? So around the 19th century, what had happened was the countries abolished internal tolls, other internal barriers. That is, there were trade between states, right? So the countries sort of undertook nation building exercises that resulted in movement of goods from one state to other. And we're talking about the European countries. So the European countries adopted free trade policies. The repeal of corn laws is cited as an example where Britain had embraced liberal trade policies, right? So with European countries embracing liberal trade policies, what could be seen is signing of treaty among European countries for movement of goods from one country to other country. That is import and export. So Britain signed a trade treaty with France. Then we do see records of France signing trade treaty with German Empire. So we do see a multitude of trade treaties being signed in the middle of 19th century. But this was for a short period. Immediately in 1870s, Europe was hit by a recession. Then Germany was the first country to adopt protectionist measure. Once Germany adopted protectionist measure, all other countries followed suit. So what happened is, from 1870, we could see there was a move from trade liberalization to trade protectionism that was being taken. Then after that, what German did was, German sort of used trade treaty as a geopolitical strategical for geopolitical strategy. What German did was, German signed a trade treaty with France primarily to isolate Austria. So here we could see German assigning treaties for political purpose, although these are trade treaties. So earlier when we saw in 1860s, that time treaties were signed purely for commercial reasons, right, on the principles of economic efficiency. But now somewhere we do see political aspirations is also get mingled in. After that, First World War happened, then all countries adopted protectionist measures. So these measures that were adopted after the First World War are also commonly known as beggar thy neighbor principles. So basically, they are protectionist measures. At the same time, if we see what is happening in the United States had Republican Party in power, and there were many trade protectionist measures that were there. One classic example is Smoot-Hawley Act. And 2 years before the Smoot-Hawley Act, there was Great Depression of 1928. So the Smoot-Hawley Act, what it did was it raised tariff on imported products. So basically, the US market was not given to the imported goods. Then, when President Roosevelt got elected, Roosevelt, along with his Secretary of State, Cordell Hull, these two persons, Roosevelt as well as Cordell Hull, more importantly, Cordell Hull's role in liberalizing American market cannot be, undermined. He played a very significant role. So what they did was Roosevelt and Cordell Hull they adopted liberal trade policies, and one particular legislation that is significant is Reciprocal Trade Agreement Act 1934. So what did this act do? This act gave power to the US administration to enter into trade treaties with other countries. After this particular legislation was passed, we could see US sign 31 treaties with other countries. One of the things that US realized was it is engaged in bilateral trade treaties with other countries. It's sort of repeating the same content when it's talking about MFN, market access, custom duties bilaterally with different countries. Then what happened was Second World War happened. After Second World War, you all know when the US realized it's going to win the war. So with its allies, it met at Bretton Woods. The Bretton Woods Conference, they decided to establish IMF, World Bank, and ITO. So that decision was taken. So here, what the countries decided was to have a multilateral trade treaty. Otherwise, what US did bilaterally pursuant to the Reciprocal Trade Agreements Act, it wanted to have a multilateral trade treaty. So they wanted to establish an organization to implement that, International Trade Organization. When this was decided that there will be ITO, at the same time UN was established. So the discussion of having a multilateral trade organization was carried forward to UN Economic and Social Council. Then eventually the meeting happened at three places: New York, Geneva, Havana. So where the version of the charter, ITO charter was being discussed, you might have heard the phrase Havana Charter. So that refers to the version of the charter that was being discussed in Havana, right? So we are working for the establishment of International Trade Organization. Meanwhile, what they do is in October 1947, so they were like, anyway, we have finalized certain rules relating to trade. Why don't we have a provisional application of this rule? So they adopted a protocol for provisional application of GATT, and 23 original contracting parties signed that agreement. So what happened was, after the ITO charter, everything was finalized. US Congress did not support for the establishment of ITO for various reasons. They felt that US interests are not being secured effectively and all of that. So when ITO did not have the support of US, which is a major country, so ITO did not see the light of the day, even though the charter was ready. So whatever the ITO secretariat that they had envisaged, that eventually became a GATT secretariat. I mean, GATT is just an instrument, right? But there was a secretariat, GATT secretariat, and that ensured the working of the implementation of GATT provisions. With that, a GATT, a very small document, which initially was supposed to be a provisional document, eventually regulated international trade until 1995. But since it was a provisional application, it did not contain broader rules. What it contained was a skeleton, right? The flush was not there. So to supplement whatever was missing in the GATT agreement, there were many negotiation rounds that were held where certain issues were discussed. And subsequently, when the Uruguay round of negotiation happened, the original agenda of the Uruguay round did not envisage the possibility of establishing a multilateral organization. But when the negotiation round commenced, the Italian trade minister, he proposed, why don't we have a multilateral organization for trade? So that's when the discussion picked up. Eventually, all the countries, the GATT contracting parties, they signed an agreement in Marrakesh in April 1994. And that agreement came into force on 1st Jan 1995. Since the agreement was signed in Marrakesh, it's also referred to as Marrakesh Agreement. Right, the English spelling is SH. The French one is with the CH, ends with CH. Or some scholars refer to as WTO agreement because it establishes World Trade Organization. Now, if we see the preamble of Marrakesh Agreement, it has broader objectives compared to GATT. Right, GATT only talks about economic objectives, but Marrakesh Agreement has broader objectives. And it clearly lays down the function of a World Trade Organization, the implementation of WTO agreements to provide scope for negotiating new rules for settling disputes, trade disputes, and for providing a mechanism for trade policy review mechanism. All of these are the functions of World Trade Organization. If we look at the organizational structure of World Trade Organization, what we see here is at the head, at the helm, we see ministerial conference. It is called ministerial conference because only the minister level persons from all WTO members attend this, right? It could be trade minister, it could be commerce minister, it could be the prime minister, and it happens once in every 2 years. And since all minister level persons attend this conference, it's widely publicized. You can, you can follow up what is being discussed in the public media. Then you have General Council, because since it meets only once in 2 years, most of the day-to-day activities are dealt by General Council. Now here, every country sends one of its representative to sit here in General Council. So General Council, the composition of General Council, DSP, TPRB is same, right? But legally they are distinct. So there's one chairperson for General Council, there's one chairperson for DSP, there's one chairperson for Trade Policy Review Board. So the DSP, the Dispute Settlement Body, it again operates on a two-tier system, just like how India has High Court, Supreme Court. So they also have a two-tier system, panel and appellate body, right? Then General Council also oversees the functioning of other councils. These are the councils that are established through Marrakesh Agreement. More than that, there are other working committees and other councils as well. Right? There is Council for Trade and Goods, which is responsible for Annex 1A documents. Then there's Council for Trade and Services, which looks after GATT, the General Agreement on Trade and Services. Council for TRIPS, then Working Party and Accession, and various committees. Those are there. Then apart from them, there are other agreements in Annex 1A which deals with trade and goods, like a TBT Agreement, SPS Agreement. So those committees are established pursuant to those agreements. They all report to Council for Trade and Goods. Then the executive organ of World Trade Organization is the Secretariat, WTO Secretariat. It is headed by the Director General. The current Director General had made history by being the first female or women Director General. The ministerial conferences appoint the Director General. The staff, the Director General, once they become a part of Secretariat, they assume international character. They cannot receive instructions from their respective governments. DSU is provided as an Annex 2 of Marrakesh Agreement, also known as Dispute Settlement Understanding. This document is primarily responsible for settling trade disputes between the country. It lays down the procedural aspect. It's like our, the procedural code. It lays down about how the dispute settlement process should happen. So the primary objective of the dispute settlement mechanism established by this document is first to aim for a mutually agreed solution. Only if that does not happen, to go for adjudication by panel and appellate body. So there will be a consultation once if the countries reach a mutually acceptable solution, then that's fine. If they don't, then they can, the complaining member can request for the establishment of a panel. Then the panel is composed. Then the panel proceedings happen. Panel issues a report. Now there are two options. The countries, the WTO members can adopt the panel report as it is, or if either of them wants to appeal it, then they can appeal it. Then an appellate process happens. Then after that, both the panel report as well as the appellate report is adopted together, because not all issues would be appealed, right? So both of the reports are adopted together, then the implementation stage happens, right? So this is a very detailed document, DSU. I mean, compared to Indian judiciary, it sort of establishes a very clear timeline. And all these timelines are in days, right? If we look at our Indian judiciary, the case goes on for years. And at every stage, there is a delay of months and years together. But here, the timeline provided in the DSU is matter of days. within 10 days, the stage should, you should move to that stage. The parties have an option to respond within 10 days. All of this is matter of days and months. Therefore, a robust dispute settlement mechanism was established. The only thing what happened was the appointment of appellate body members had to be through consensus. That is, all WTO members had to agree on the name of a particular individual so that he or she can be appointed as the appellate body member. So with US opposing the nominations that were being suggested, so there could not be any appellate body member to be appointed. Eventually, appellate body became a defunct institution, and therefore, with no appellate mechanism, what's happening is there is a right conferred on the parties to go for appeal, right? So some of the countries, when they are, when they do not agree with the panel report, they're just appealing in void. So that sort of convolutes the otherwise robust dispute settlement mechanism established by DSU. Okay. So there are other principles, international trade principles that we see in Annex 1A agreements, starting with the first agreement, GATT. We first talk about the rules on market access, because these two rules are the one that through which a government can regulate the import and export flows into the country. So what a government could do is, a government could ban the import of a particular product, right? So, or it could ban the export of a particular product. I think recently the last ban that India has issued was with regard to basmati rice, if I'm not wrong. So export of basmati rice. So the government could impose a ban on the import or export of a particular product, with which it can sort of regulate international trade. I'm not using the word hinder. So this is one sort of a mechanism. So the first principle that we're going to discuss today is, what does the GATT talk about with regard to this ban? Is that Article 11 of GATT says that generally the country should not impose a quantitative restriction. When we say quantitative restriction, any number, any quantity. Ban would mean the number is zero, right? The government also cannot say you can only import 10,000 tons of this particular product. So any number is also a quantitative restriction. So GATT, what it says in Article 11 is, do not impose any quantitative restriction when it comes to import and export. Regulate the international trade through Article 2. What does Article 2 talk about? Is regulated through tariff measures. So tariff measures also the amount of custom duty that a country imposes on a product, that could also regulate your import and export flows, right? You put a heavy custom duty on a product, obviously it's going to be very costly in the market. Then the number of consumer buying that product will also go down. So eventually, when there's no demand in the country, then you are effectively regulating the import of that particular product into the country. So there's an option for a country to regulate the trade through tariff, but what Article 2 talks about it, so that the country does not charge an exorbitant custom duty, a bound rate is recorded. What is it? That the maximum amount that you're going to levy. So that the countries have already recorded what is it the maximum amount they will levy. So this had come pursuant to negotiations. The tariffs are recorded. So the whatever tariffs that are recorded in the schedule of concessions are known as bound rate. It is up to the country. It's like an MRP. The country can levy that much rate, or it has to levy something lower than that, not higher than that, not higher than the bound rate. So through which now two major problems that can come in the in accessing the market of other country was sorted by GATT, by saying that you cannot put quantitative restriction. There are some exceptions, right? There's some exception in the second paragraph itself. Then there are general exceptions and all of that. But we're just talking about the basic rule. What does it talk about? So the basic rule is you cannot put quantitative restriction.
Are qualitative restrictions valid under Article 11?
So that's what Article 11 says. No country can impose quantitative restriction. The basic rule is you cannot impose quantitative restriction. If you want to regulate it, do it through tariff concession.
Quantitative restriction, not
qualitative. So we'll discuss TBT agreement also, right? Okay, so then Article 2 talks about the maximum tariff that a country can levy. After that, two other principles that are considered to be very cornerstone principle is that anti-discriminatory provisions. So you will find Article 1 of GATT dealing with most favored nation treatment and Article 3 talking about national treatment. So here, both of them, it's like, talks about equal treatment to be given, but the way it operates is something that we should know about. Most favored nation treatment, it talks about, it acts in the form of a negative equality in the sense that MFN Article 1 says that any favor, privilege, immunity given to the products of one country has to be extended to the products of other country. So essentially, Article 1 talks about comparison of products, imported products from different countries, right? So here, what the another essential feature is when you talk about the comparison whether same treatment is given or not, you also look at whether the products are like products or not, right? You cannot compare a smartphone with that of an ordinary button phone, right? So that the products have to be like products. And it also operates in this way. If you grant an advantage or a favor or an immunity or a privilege beyond your applicable legal framework, like your legal framework says something, but you are doing, more than what your legal framework permits, then that also has to be extended. So you cannot at that time take a defense. This is what our law says. This is what our regulation says. Any favor is given to the product of one country that has to be extended to other countries unconditionally and immediately as well, right? So then again, there are certain exceptions to MFN. One of the biggest exception is certain preferential treatment could be given to developing and least developed countries. So there could be a generalized system of preferences that is allowed. Then you have Article 3 that talks about national treatment, the comparison that we discussed in the context of products from other country. Here in national treatment, the comparison is between the domestic product and imported product, right? So you cannot give any tariff or a non-tariff measure favoring the domestic products, then that would violate Article 3 as well. So here also the like product, it has to be given only to like product. But an interpretative note says that it does not only extend only to like product, but also to directly competitive and substitutable products as well, right? So we do see many cases which develop the jurisprudence of Article 3, US malt beverages, Japan alcoholic beverages, then you have EC asbestos, wherein a much the jurisprudence of Article 3 was developed. And after the rules with regard to non-discrimination, the GATT also contains certain rules for rectifying unfair trade, right? So these are also called as trade remedies or provisions rectifying unfair trade. So the first one is anti-dumping. So it is given under Article 6 of GATT. So like I mentioned in the beginning of the class, GATT was a very small agreement, right? So much detailed provision with regard to dumping is provided under anti-dumping agreement, a separate agreement was agreed by the members. So Article 6 and anti-dumping agreement regulates the concept of dumping, which is a unfair trade practice. Now, what is the objective of that? So what might happen is, I mean, for instance, China is known to dump products in other jurisdictions. So here what happens is the product that is sold in its own market is actually higher than the price at which it is selling the product in other countries, right? So what might happen here is there are certain negative effects of dumping when there are cheap imports coming from a particular country, especially so when they are selling the same product at a much higher price in their own country, then your domestic products cannot withstand the competitive effect, right? So in that case, what happens is you can have a domestic investigating authority. They will look at the effect of this particular dumping. They will see first whether there is dumping, whether that dumping contributes to material injury. Then if there is a link between dumping and material injury, then you can take certain measures against the industries that are engaged in dumping, right? Only to the extent of dumping margin. You cannot penalize whatever is the loss that happens is a dumping margin, right? So only to the extent of dumping margin, you can take rectifying measures. So this is again very specific to a particular exporter who's engaged in dumping. So it could be in the form of anti-dumping duty, or it could be other provisional measures. You can take a price undertaking also that you will not sell it at a cheaper price, right? All of these could be taken. So anti-dumping agreement do contain a detailed procedures, rules as to how this investigation should go, what sort of calculation should be done. Then the second unfair trade practice that we see is, sometimes subsidies are given which has a very distorting effect in international trade. Once a subsidy is given to a particular product, what could happen is that product is available for a cheaper price, which in turn gets sold more, right? So the imported products will not be sold. So the imported product gets affected. The other way it has a distorting effect is, providing subsidies to industries is, what would happen is the subsidized product is exported. So it is again cheaply available in the exported market as well. So therefore, there the domestic product cannot compete with this, and also the imported product from other countries cannot compete with it. So subsidies do have a trade distorting effect. So Article 6, Article 16, and agreement on subsidies and countervailing measures do provide a detailed disciplines on regulating subsidies as well. So there is what is considered to be a subsidy. There is a financial contribution either by a public body or directly by the government of a WTO member. A price or an income support is given which confers a benefit to the domestic producer, and this should be a specific subsidy. Right? If it is given at a broader scale, then that will not be questioned. But if it is a specific subsidy, then that could be questioned. So in case of subsidy, there are two options that a country can take. One is they can directly take a countervailing measures, but if they directly take a countervailing measures, then proper investigation had to be done. So the investigating authority will see whether there's a subsidized imports, is it causing material injury, is there a link between these two? Only then a countervailing measures can be taken. Otherwise, a multilateral track could be undertaken, that is DSP could be approached, consultation request could be filed. The third thing that we will discuss is with regard to safeguards. So this is something Professor Peter calls it as economic emergency exception in his book. So what it does is, this is technically not an unfair trade practice because they're not. It's not technically unfair. What here happens is, for some reason, the import of a particular product is more, right? There's an increased import of one particular product all of a sudden that is more in such a way that it causes or threatens to cause serious injury to your domestic producers. In that case, a country may be allowed to take safeguard measures, and this is temporary in nature, only to protect your domestic industry. Like, you cannot have a permanent measure. So this is there's this particular provision in GATT Article 19. So that talks about taking a safeguard measure. Then eventually we have a detailed agreement, safeguards agreement. So if we have to read both these together, Article 19 as well as safeguards agreement. Article 19 had one more word, unforeseen development in the provision, but that is not there in safeguard agreement. So eventually, pursuant to one particular case, what are the requirements for a country to take a safeguard measure? There should be increased import, there should be serious injury, there should be causal link, as well as the requirement from Article 19 should also be shown that this development, that there will be an increase in import, was not foreseen by the importing country.
Can serious injury be foreseen, or does it have to happen for
the increase in import? If it is foreseen, then you're not sort of satisfying this particular requirement.
serious injury has to take place?
Serious injuries with regard to the domestic producers. It could be, it should cause serious injury. The serious injury is threatened, like it may happen. So these are the major things, principles when it comes to international trade is dumping, then your subsidies, which has a trade starting effect, then safeguards agreement. After that, the most important provisions which is relevant for this course, WTO law on the climate crisis, is exceptions given under GATT. Right, if a country is seen sort of violate any of the GATT provisions, then the one other way it could justify that measure is if it shows that our trade measure falls within the general exceptions provided in Article 20. So Article 20 sort of acts like a justification for otherwise a violating measure. So the trade rules are not very absolute, right? So when it comes to liberalizing trade, right, no restriction on import versus when it comes to protecting the life of an individual, which one would you choose? So that point of time, the trade rules go out of the window if it's about the life of a person, right? So Article 20 do talk about these exceptions. First, there is an introductory paragraph to Article 20, which is generally called a chapeau, a French word which means hat. So there are certain requirements that are laid in the chapeau. Then you can see the specific public policy objectives that a country can take. So the most important or the most invoked exceptions are Article A, necessary to protect public morals, and B20B, which talks about necessary to protect human, animal, plant life or health. Then G, which talks about conservation of exhaustion of exhaustible natural resource, provided such restrictions also placed on the domestic production as well, right? So these are the most invoked. So in terms of the trade measures that will be taken in the light of climate crisis, either 20B or 20G will be applicable for that. So you have other qualifiers here. So if you see here, some of the provisions start with the word necessary and some of the exceptions start with the word relating to. So the cases that we decided under Article 20, they are clarified. So the reason it was drafted, some public policy objectives are used in the context of it should be a necessary measure to protect that objective, and some are used in the context of relating to. So the drafter has sort of given accordingly the weightage as well, right? If a measure, if you want to defend a measure under 20G, then what you need to show is it is just a relating to, right? Relating to achieving a particular objective, public objective. But if it is qualified by the word necessary, then you have to show that is the least trade restrictive measure. That is, no other alternative should be available, right? After showing that there's a two-tier test that is developed, what the panel and appellate body would do is, when you want to justify, when a country wants to justify a measure under Article 20, first it has to show that it falls under any of these public objective that it is trying to achieve. Then it also has to satisfy the requirements mentioned in the introductory paragraph. What are the requirements mentioned here?
They should not be arbitrary or unjustifiable. They should not be discriminating.
Yeah, arbitrary or unjustifiable discrimination between countries where the same conditions prevail, and it should not be a disguised restriction on international trade. So most importantly, what could happen is a measure that is taken or that is shown to be an environmental measure could also be a disguised restriction as well to protect the interest of domestic industries. So therefore, that the requirements mentioned in the chapeau should also be satisfied, along with proving that it is actually relating to one of the public objectives mentioned here.
Can you not invoke one, two simultaneously?
We could do that. For example, the US gasoline, they invoked BG. So it is easier to satisfy the requirement under G than B because of the qualifier necessary. Then there are other exceptions given in the 20. The one other exception, I mean, earlier it was in the GATT era, Article 21 was widely used, but post World Trade Organization, it was not used much. But nowadays it's been invoked, right? The security exception is invoked. It's a very broad one. So you cannot it can have any measure with regard to trade in arms, ammunition, then trade measures taken in the time of war or other emergency. The other emergency again has a wider connotation, as we see from the Russia transit case. Then any action that is taken for the maintenance of peace and security. So there is some sort of leeway given to a country to take a trade measure which otherwise violate the GATT rules but could be justified under security exception. So another thing that I have included here in the discussion was TBT agreement and SPS agreement, because you'll be studying the palm oil case, EU palm oil case. So therefore, we'll talk a little bit about this. This talks about your qualitative restrictions as well. So what happened was certain non-tariff barriers were taken. So Article 2, after GATT came into force, Article 2, Article 11 sort of took care of the problem when it comes to accessing other countries' market, right? So tariff binding was given under Schedule of Commitments. You cannot put a ban or you cannot limit the quantity. That was taken. So countries were getting innovative. So non-tariff consideration was put on the product. That is some sort of a technical regulation, right? It has to be of this particular weight. It has to be labeled in this way. All of these were done. So in the Tokyo round, if you remember the negotiation rounds that I showed you after GATT came into picture, there were many negotiation rounds. So one of that happened in Tokyo. So in Tokyo, 6 codes were adopted. What happened here was the provisions in GATT was very minimal. So therefore, detailed provisions were adopted in the form of code, but it was plurilateral in nature. That is, those countries which separately agreed to these codes, it was only binding on them. But when the WTO was being established, so there were agreements that were developed out of these codes, and that became binding on all members because of single undertaking concept. So WTO operates on the concept of single undertaking. You cannot pick and choose. What happens is, if you are a member of WTO, you're bound by all the agreements that are mentioned in Annex 1A, 1B, 1C, Annex 2, Annex 3 of Marrakesh Agreement. Annex 4 of Marrakesh Agreement talks about plurilateral. Only that the countries that have signed those agreements, it is binding. Otherwise, it operates on single undertaking. So here, whatever was on plurilateral framework, eventually in 1994, there was a TBT code that was adopted in Tokyo round, which eventually became TBT agreement and SPS agreement in 1994 on a multilateral under the concept of single undertaking. So they're mutually exclusive. So why was these agreements adopted? To ensure the quality of the product so that there's no danger to the life and health of human, animal and plants, and also to prevent deceptive practices. Now, what does this agreement talk about? Talks about technical regulations, standards, and what are the measures or methodologies that you use to assess whether these technical regulations and standards are complied, right? So conformity assessment procedures, that is dealt in TBT agreement. So TBT agreement is basically nothing but a document that lays down what should be the product characteristics. If you want to import a particular product, then you lay down. So these are the characteristics that I need in that particular product, right? What are the production methods and whatever is laid down, and that has to be mandatorily complied with, then it becomes technical regulation. But if it is only voluntary, then it is known as standards. Then how do you test whether the product imported conforms with whatever you had asked for? Then that is dealt through conformity assessment procedure. On the other hand, what is contained in an SPS agreement? So SPS agreement is with regard to sanitary and phytosanitary measures, right? So basically, if there is a characteristic related thing, but that falls under any of these things, then it will be dealt under SPS. These both agreements are mutually exclusive, right? So you can bring the allege the violation of that measure either under SPS or under TBT. Then the other important agreements that we see in the context of international trade, and something that is very relevant for India, is General Agreement on Trade in Services. This is an agreement that India opposed initially during the Uruguay round. It was not ready to give concessions in the service sectors. But now India has submitted a proposal on services facilitation before the World Trade Organization, right? So basically what GATS does it's very difficult to define the term service. So what GATS, the document also does it only talks about 4 modes of supply of service rather than defining service itself. So 4 modes of supply of service is covered under GATS, which regulates trade and services. The first mode is cross-border supply. Cross-border supply is when the services are supplied from the territory of one country to somebody who is in the territory of another country, right? So then consumption abroad is when there is the supply of service territory there in the territory of other country. Then in that case, we say that there is consumption abroad. Then there is commercial presence. Commercial presence is your FTI, right? There's a subsidiary established in the territory of other country, so there's a commercial presence in the territory of the other country. Then the fourth one is movement of natural person. So movement of natural person is people move from one country to other country for the supply of service. So these are the 4 modes of supply of service. So unlike GATT, where the rules are there, if you want to derogate from the rules, then you have to take waivers or you have to justify your measure and either of the exceptions. But GATS, the commitment works in this way that it's based on a positive list approach. Country can sort of talk about what is a commitment that they are willing to undertake in a particular sector, then they write it, right? This is what I'm willing to undertake in this particular sector. So there are 3 different ways in which you can liberalize trade and services in different sectors. One is you can take a full commitment where you write the word none, or you can put in certain conditions that is known as commitment with limitations, or you don't want to liberalize a particular sector, then you don't take any commitment itself, right? So either of these things are possible, and this is recorded in a schedule. Then you have TRIPS as well as TRIMS, 2 other agreements that are actually trade related measures, not technically trade one. So TRIPS is again with regard to intellectual property rights. TRIMS is with regard to trade related investment measures. So there are certain TRIMS aspects that Professor Bossche will cover in his lectures, especially the Canada renewable energy case, India solar cells case. But this sort of gives you a brief overview of what currently the rules that we have with regard to international trade or the WTO agreements. If there are any questions, we'll discuss that.
You explain theory.
Heshker-Ollin theorem. So what is the other examples that we saw? Comparative advantage and this thing. It only spoke about one factor, right? So what Heshker-Ollin theorem talks about is different countries have, there are 4 factors of production. So there are some resources available abundantly in a particular country. So Heshker-Ollin theorem suggests that a country should focus on manufacturing a particular product that uses abundantly available resource in the country, right? If you're a very small country with limited land resources, then you should not engage in manufacturing certain products that sort of uses land extensively. If you're a country with human resources, then you focus on labor intensive production of products. So that's what it talks about.